And me being an academic, I have had interest and I've had interactions and deliberations on this topic since some time now. The format of the session is it's a long session, so there will be short lectures. However, I would prefer this session to be as interactive as possible. And as and when any member may have any questions or observations, you are free to raise. You can raise your hand or you could type in the chat, and I will welcome all of those interactions. So first, we want to know what is cross-border insolvency and why do we need it. So nowadays, or in the global economy, companies have operations across the borders. So companies will have operations, they will have assets, they will have business across the borders. But a particular law will be applicable only within that particular jurisdiction. And some of you who may have grappled with cross-border cases, you are all CS, company secretaries. You may also be chartered accountants, and even before insolvency, you may have come across cases regarding recovery or issues, financial issues regarding companies and assets abroad, and how to serve the process abroad. So all of those issues are addressed to a certain extent under the existing laws. However, now when we come to the issue of insolvency, there is a need to first is that there is a need to serve the moratorium. So if the insolvency application is admitted, moratorium is imposed. And when the moratorium is imposed, it has to be, in India, it is like automatic, So whenever an NCLT will impose the moratorium, it will be recognized as a moratorium throughout. So regardless of you have to go to that particular court. But if that does not happen outside, so when the moratorium is imposed by NCLT and the RP or the IRP at that time comes to note that there are certain assets abroad uh, perusing through the books of accounts, then you will have to go to that foreign jurisdiction and you will have to apply to the foreign court to recognize and enforce that moratorium. Apart from that, the RP or the IRP may also request and may also require some other assistance from the court. So in short, as you can see, cross-border insolvency is a necessity to deal with insolvent debtors with assets across several jurisdictions, and it aids with the insolvency process for the Indian multinational with subsidiaries and assets in foreign jurisdictions undergoing insolvency process. It's essential to improved credit recovery rate, information exchange without delay, and it also empowers insolvency representatives and provides remedy in foreign jurisdictions. So if the enabling legislation or the legal regime is not there, you may go to a foreign country and they will say, why should we recognize this NCLT order? What is, do we have any legal regime? What is the law or the legal structure wherein we can recognize and enforce the foreign courts, insolvency courts orders? Uh, so then it seeks to let foreign creditors and bankruptcy professionals initiate or take part in the bankruptcy action in an Indian tribunal, and it covers Indian lenders requiring assistance in another country against India businesses and corporate debt guarantors with overseas assets. And a cross-border insolvency regime is expected to help creditors to trace global assets of defaulting debtors and recover dues. So, in my presentation, I have basically focused on the draft part Z, which has already been in 2018 was floated in the public domain, and then in 2020 21, the IBBI, the board, has also released the draft rules and regulations on cross-border insolvency. So the presentation takes into account not only the what is the model law, but basically what are those provisions which in the draft has been adopted or seeks is sought to be adopted in India. So, so this is so as far as the part Z is concerned, it applies to corporate corporates only and not per individuals. So corporates or guarantors to corporates. So as the basis of the IBC. So whatever is enforceable, whatever is in force under IBC in India, only to that extent the cross-border insolvency will be also in force. So if personal insolvency is not in force, it does not cover financial institutions. They also are kept outside this purview. So trying to understand the overview and how international institutions can influence domestic insolvency law, how cross-border insolvencies may be resolved, the discharge of debts governed by the foreign law, what are the ancestral principles and guidelines. And apart from that, now we have the model law on recognition and enforcement of insolvency related judgments, and also the model law on enterprise group insolvency. So the model law on cross-border insolvency was drafted in 1997, and it sort of came into force in 1997. So it's over 25 years now. And now we have two more model law which are addressing the contemporary developments, which is the group insolvency and also the insolvency judgments. So what is this in ancestral model law on cross-border insolvency? Few aspects. There is a voluntary framework and it's merely a recommendation. States can determine when and to what extent to adopt the model law. It also facilitates cooperation between courts and the insolvency professionals. The model law enables insolvency professionals to gain recognition of insolvency proceedings. The main themes are four: access, recognition, relief, and cooperation. And so far, around 53, 54 countries have adopted the model law. Now, what is the model law on cross-border insolvency, and what is the status of it being adopted in India? So the UNCITRAL model law on cross-border insolvency has been drafted by UNCITRAL. UNCITRAL is the wing of the United Nations, which is the United Nations Commission on International Trade Law, which drafts draft laws and laws, that is convention, treaties, to regulate the business law or the trade law or the international trade law, basically. So this is in relation to the regulation of corporate insolvency and financial distress involving companies which have assets or creditors in more than one state. And in 2018, the Ministry of Corporate Affairs released the draft Part Z on cross-border insolvency, which was based upon the model law. So how to understand these instruments? So there is a work which is going on in the UN and UNCITRAL, and how to understand these various type of instruments, which you understand as the convention and the model law. So some of the best examples that I can provide to you is to better understand is the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards of 1958, which was adopted in India as the Foreign Awards Recognition and Enforcement Act of 1961. So the convention is a law, the treaty law, which is adopted by the United Nations. And that same law is adopted as it is by enacting it as law in India. So it is the law which is enacted and a draft law which is then enacted as an act in India. Then another model is the model law, and the best example is UNCITRAL Model Law on International Commercial Arbitration of 1985, which was referred in India to draft the Arbitration and Conciliation Act of 1996. The Arbitration Act of 1996 was enacted in India, and reference was made to the Model Law on International Commercial Arbitration of 1985. So the purpose is twofold, that to promote international trade, the law also must be uniform or harmonized. So that should be similar so that the people, the business people, this law should not be difficult so that it is to be interpreted and understood only by the legal experts. The purpose of business law is that it should be simple for the business people to understand and also for the practitioners like you who can simply and easily understand it. There is a uniformity. The law is expected to be the same across jurisdictions, and that is the purpose of the UNCIT trial, and that is why we also recognize and give due deference to these international instruments in the form of conventions and model laws. Now, moving on to the ancestral model law on cross-border insolvency. The date of adoption was 30th May 1997. And the purpose is that it is designed to assist the states to equip their insolvency law with a modern legal framework to more effectively address cross-border insolvency proceedings. And this concerns debtors experiencing severe financial distress or insolvency. Then the purpose is that is focus on authorizing and encouraging cooperation and coordination between jurisdictions rather than attempting unification of the substantive insolvency law, and respects the differences amongst the national procedural law. So the procedural law will be different, and that is not touched. That is left as it is because every country will have their specific jurisprudence, their procedural law, their court systems. So there is no attempt made to harmonize those domestic institutions. In other words, a cross-border insolvency is one where the insolvent debtor has assets in more than one state, or where some of the creditors of the debtor are not from the state where the insolvency proceedings taking place. So the key provisions are, as I mentioned to you, four. There is access, where representatives of the foreign insolvency proceedings and the creditors get a right to access to the court to seek assistance, and also to authorize representatives of local proceedings to seek the assistance elsewhere. Then there is recognition, and these are simplified procedures for recognition of the qualifying foreign proceedings and appointing the foreign representative. As a qualifying foreign proceeding is defined either as a main proceeding, which takes place where the debtor has its center of main interest, or the COMI, or it can be a non-main proceeding, uh, which is at the place of the establishment of the debtor, and effects are the relief accorded to assist the foreign proceedings. So we'll take on in detail what are these two types of proceedings, the main proceeding and the non-main proceeding, and then the relevance of the center of main interest, COMI, and establishment. Then the third principle is relief. So interim relief is at the discretion of the court, and automatic stay upon recognition of the main proceedings is provided. Then the fourth is cooperation and coordination. There is cooperation amongst the courts of states where the debtor's assets are located, and coordination of concurrent proceedings concerning that debtor. So what is the applicability of the cross-border regime? The code provides the adjudicatory authority with the power to refusal to take any action for implementation which, in its opinion, ought to be manifestly contrary to the public policy of India. So the law still provides that the adjudicatory authority, which is the NCLT, may refuse to recognize and enforce any foreign proceeding which may be contrary to the public policy of India. So the system is that the foreign representative has to apply to the adjudicating authority, and the foreign representative shall be bound to follow the code of conduct as may be notified by the board. So the board in the 2020 rules and regulations have also issued some guidelines, some best practices, where the foreign insolvency professionals will be expected to follow some code of conduct. An application pursuant to this part is made to the adjudicating authority by a foreign representative does not subject the foreign representative or the foreign assets and affairs of the CD to the jurisdiction of courts in India or the adjudicating authority for any purpose other than the application. The penalty provisions for the foreign representatives when any loss of amount or unlawful gain on behalf of the foreign representative take place. So, what is the applicability of the cross-border insolvency framework in India? This is as per the draft part Z, which has been floated in 2018 itself, and basically it is in consonance with the portions of the IBC which have been notified and brought into force. So the cross-border insolvency will also be applicable to company, the body corporate, or the LLP. It is not applicable to individuals and also not applicable to the financial service providers unless specifically notified. So applicability of the IBC to foreign companies and the foreign LLPs. The provisions of the IBC to be made applicable to entities which are incorporated with the limited liability under the laws of a foreign country and also having an establishment as defined in Part Z in India. So, which are the designated branches for which will adjudicate the cross-border insolvency matters? Now, as per the draft law and the rules and regulations draft issued by the board, all the benches of the NCLT to be vested with the jurisdiction to deal with applications under Part Z. Now, why it is, again, one question is why this is named as Part Z in the draft. It could be regulations. So one question is why this is named as Part Z and not regulations. The board issues several regulations. So whether the board could have notified the cross-border insolvency as regulations, but we for this we may go back to the joint parliamentary committee, the debate in the parliament when the IBC was being introduced, and at that time it was discussed. The finance minister also mentioned that cross-border insolvency is important and it will be included in the IBC, but because at that time in 2016 there was a need to enact and pass the IBC, and it was felt the cross-border insolvency provisions require some more deliberation and detailed discussion on the point. Hence, at that time, only two provisions were included, and very soon, just within 2 years, the Ministry of Corporate Affairs issued this draft and named it as Part Z, and it signifies that the intent is that there will be an amendment to the code, and this Part Z will be added as a part, the next part to the IBC, to the Insolvency and Bankruptcy Code. So like we have Part 1, Part 2, Part 3, Part 4. So similarly, the next part will be the cross-border insolvency. So cross-border proceedings, so all the benches of NCLT will be vested with the jurisdiction. And this is basically to signify that assuming a particular company, a CD, has a registered office in a particular state, then that the convention that wherever there is a recovery suit, usually the suit is filed or to try to be enforced in the jurisdiction where the debtor's assets lie. So wherever the company's assets are there or the head office is there, it is good to bring the suit because the legal process can without much difficulty or easily uh, take possession and realize those assets. So intent is that the cross-border insolvency application will be filed in the NCLT, where the corporate debtor will have its registered office or will have its establishment. Some substantial assets will be there. So hence, all the NCLTs will have jurisdiction to try to take these cross-border insolvency matters. So cross-border proceedings arising out of India's CD will be dealt with at the bench having jurisdiction over the location of the registered office of the CD, but insolvency proceedings pertaining to foreign companies to be dealt with by the principal bench of the NCLT only. Now, the framework for access to and regulation of the foreign representatives. The foreign representatives to be given access to the insolvency system and infrastructure in India for the purpose of cross-border insolvency proceedings. The foreign representatives acting in cross-border insolvency proceedings in India to undergo a minimalistic authorization process with the board, which will be considered to be a deemed authorization. Then the regulations also provide that a principle-based, a light touch code of conduct to be applied to the foreign representatives acting in the cross-border insolvency proceedings. The board will also be empowered to undertake investigation and the disciplinary actions against misconduct by the foreign representatives. So there are, concerns in some countries. There is no regulation, that there is no the profession is not regulated. So the USA, the profession is not regulated. So what will determine the regulation or the code of conduct and disciplinary matters? So even if they may not be regulated, but they are recognized to act as insolvency professionals, so we will also recognize them, but we will have the board will identify some code of conduct which is termed as the light touch code of conduct, and the board will also be authorized to initiate disciplinary proceedings and investigation against these foreign representatives. So what is the framework for access by India IPs to the foreign proceedings? So neither the insolvency code nor the IP regulations restrict an IP from applying for accessing the insolvency system of a foreign jurisdiction. So it has happened before, even if in India we do not have a cross-border insolvency framework, but some countries under some principles which are called as the principle of comity will recognize the court processes. So as it has happened in some cases, and I will be taking and explaining to you certain instances where, despite not having a cross-border insolvency uh, framework in place, some foreign courts, especially the USA, they have recognized the moratorium of NCLT and they have given effect to it. So the requirement on the IP to report such assignments to the board to specify the format and manner in which such reporting must be made. So the notice of proceedings. When a notice is required to be given to the creditors of a CD during insolvency resolution, liquidation, or in connection with any other proceeding under the IBC, such notice must be given to known foreign creditors in accordance with the provisions of the IBC, the rules and regulations issued under the code. Where it is not possible to give such notice to the foreign creditors, the following shall be deemed as sufficient notice. So how will these requirements of notice suffice? So publication of the notice on the website of the corporate debtor, and then publication of the notice on the website designated by the board. So these are the existing forms of notice, and these will also be deemed to be sufficient notice. An application made by the foreign insolvency representative under Part Z in respect of a CD, he must supply a copy of the same to the corporate debtor or its IP if a domestic insolvency proceeding is pending in respect of CD. Where a domestic insolvency proceeding is instituted in respect of a CD and a proceeding under Part Z is pending with respect to such a CD, the person instituting the IBC proceeding must supply a copy of the application to the foreign representative in the proceeding under the Part Z. So these are some of the provisions with respect to the notice. Apart from that, so the committee, which is the CBIRC, which is the cross-border insolvency regulations committee, considered two issues in respect to the COMI determination. So what is COMI? This is the center of main interest. And they considered the factors to be considered in determining the COMI, where the presumption of the registered office as COMI is rebutted. And secondly, the effective date of COMI determination. And then in case the presumption of the CD's registered office as the COMI is rebutted, the identifiable place of central administration of the CD is the key consideration for the determination of its COMI. So these are based upon cases which I am going to explain to you. So where the COMI is rebutted and where will how to be determined. So I will explain all those circumstances when we are taking those cases. Then there is an effective date for the COMI determination. The rules to be issued by the central government must codify the date of commencement of the foreign proceeding as the effective date for the purpose of determination of COMI, and the date of commencement of the foreign proceeding shall be determined as per the local law of the jurisdiction in which such proceeding is initiated. So these are also based upon some foreign cases. These are all foreign leading cases which have been referred and which form the basis of these principles and guidelines, and I have in this PPT will explain to you. The presumption in favor of the location of the registered office as the COMI will apply only if the registered office of the corporate debtor has not been moved to another country within the 3-month period immediately preceding the date of commencement of the foreign proceeding in such country. So this is also based upon a leading case. So, there are apprehensions that, okay, I know that I'm facing distress and insolvency proceedings may be filed against me, and may want to avoid a particular jurisdiction, may want to avoid, let's say, India, and then moving the registered office to another country, let's say Hong Kong. And the creditors, then after this registered office is shifted, they file the insolvency application, and it's always it's always available for the CD to argue that my registered office now is in Hong Kong, it has been shifted, so India should not admit the insolvency application. But this proviso says that if the registered office is shifted within 3 months, then the shifting of registered office can be disregarded. So the rules on cross-border insolvency proceedings to provide for the following. So these are already there in draft format, and these are quite detailed. And this is, the draft law is already there. So this is what I am trying to discuss with you. So while determining the CD's COMI, the adjudicatory authority shall assess where the CD's central administration takes place, and that is readily ascertainable by third parties, including its creditors, as on the date of the commencement of the foreign proceeding. The date of commencement of the foreign proceeding will be determined as per the local laws of the national jurisdiction in which the foreign proceeding is initiated. In making the determination on the corporate debtor's central place of administration, the AA shall have regard to other relevant factors, including the location of corporate debtors' assets, the location of corporate debtors' books of account, the location of the CD's directors and senior management, the location of the CD's creditors, the location of the execution of contracts, and the applicable law to key contracts and disputes. So usually you might have come across that whenever the loan agreement is being signed, or parties are taking offshore loans, or there are subsidiary in foreign countries where they are taking loans. So in these loan agreements or financing documents, there will be usually two clauses. One is called as the choice of law clause, and one is called as the choice of court clause, and also the dispute resolution clause. So the parties will always decide in a foreign jurisdiction in case of a cross-border contract transaction, what will be these, how these aspects will be resolved. So location where the financing was organized or authorized, or from where the cash management system was run. Then G, location of the corporate debtor's primary bank account. And H, location from which the corporate debtor's purchasing and sales policy, staff, accounts payable, and computer systems were managed. Then the discretionary relief in cross-border insolvency cases. So these are the discretionary reliefs which can be recognized, can be provided by the court. So this is all in the CBIRC, that is the regulations, the cross-border insolvency regulations, the draft, which is already there in the public domain. So five types of discretionary reliefs can be availed of from the adjudicatory authority. Participation in proceedings pertaining to the corporate debtor. Then secondly, information sharing. Thirdly, protection of assets. Fourthly, collection of claims. And fifth, on the realization of assets. So these five discretionary reliefs can be, is within the discretion of the adjudicatory authority. If it considers fit, there are facts and circumstances, these reliefs can be applied. So even for the IPs, the IPs also, you can advise your clients that if someone asks you, your client will ask, what are the discretionary reliefs which can be available in India? So these are the discretionary reliefs which can be provided. Then moving on to some leading cases, you are already aware, Macquarie Bank versus Shilpi Cables case. So it was held that even though the creditor was a foreign creditor, but that does not restrict the creditor from filing a claim. So this is, the creditor is filing a claim in India. So creditor may be a foreign or a domestic, that does not make a difference. So this 2017 case just reiterates uh, which was mentioned in the leading case, which is probably the first case of, maybe considered to be the first case of cross-border insolvency in India, by the Supreme Court in 1962. That was the Raja of Vizianagaram case. And in that case, there was a foreign company, there were foreign creditors, and there was no cross-border insolvency law. And a protocol was developed for the cooperation and the coordination. Foreign creditors wanted to submit their claims, and the domestic creditors claimed that first, all our claims must be resolved, and then only the foreign creditors' claim be entertained. But the court said that no, the creditors are creditors, and there should be no difference between domestic or foreign. And in that case, there was this Raja of Vizianagaram, there was a company, and the company had huge assets in India. So the assets were realized, and the creditors were paid in full, 100% were paid to the creditors. And then again, the law is established that whatever remainder is, surpluses remains after all the creditors 100% claims are satisfied, that goes to the owners or the equity shareholders. So remaining surplus, which was also substantial, was distributed amongst the equity shareholders. This is the law which is in place in India since 1956, at least, if not prior to that. So the cell manufacturing case, as some of you might be aware, there was this cell manufacturing company insolvency in NCLT Chandigarh, and the NCLT Chandigarh gave admitted the insolvency, and moratorium was imposed. So the IP, the RP went to US because there were some assets, and the RP wanted the moratorium to be imposed, or the asset to be considered for the benefits of the creditors and the stakeholders. So moved the Section 15 application, which is the cross-border insolvency in the US bankruptcy code, which accommodates the technique. Then So the India indebtedness continuing forthcoming before NCLT Chandigarh bench got unexpectedly acknowledgement as unfamiliar fundamental procedure inside the importance of Section 1502, subsection 4 of the US Bankruptcy Code by the US Insolvency Code. So this came after application documented by the agent credited India as the focal point of principal interest, which was self-fabricating. So the court held that the recognition of the India insolvency proceeding is not contrary to the public policy of the US, and the US court recognized the India insolvency proceeding basis the committee. So even if there was no legal structure or legal regime, but still, it depends upon the discretion of a particular country. They may or they may refuse. So several countries will refuse, like in India. We'll come to that in the case of Jet, when the Jet insolvency was admitted in Netherlands. The Dutch administrator came to India. The Bombay NCLT refused. So they said that we do not have any cross-border insolvency, and we cannot recognize. So in the Cell case, in the US, despite there being no cross-border insolvency arrangement, but considering the principle of comity, the US Bankruptcy Court recognized the NCLT Chandigarh order. Then Jet is so Jet had certain operations in the Netherlands on an application by two operational creditors in the Netherlands for unpaid sums. Jet was declared bankrupt, and liquidator was appointed for realizing the Jet's assets. And you can, through this we also get to know the difference in the insolvency laws of different countries. In India, we adopt a step-by-step approach. The insolvency application is admitted, and after that the RP tries for resolution. Only in case of unsuccessful resolution will the liquidation be ordered. But this is not so in Netherlands. In some countries, directly a liquidation application may be filed. So here in this case, this insolvency application was for liquidation, and liquidation was ordered. And this liquidator, the Dutch liquidator, came to India to, so the asset that were the airplanes were in Dutch only. So they wanted to sell the planes, but they first wanted to get this application recognized and enforced in India, that they want to liquidate the company. So it's not just the assets. There was not much functioning, so they wanted to liquidate the company, not just realize those assets. So when the insolvency application was cross-border insolvency application was filed in NCLT Mumbai, the NCLT Bombay, it refused to recognize. It said that we do not have any cross-border insolvency law and we cannot do so. And the Dutch administrator filed an appeal in the NCLAT. And by that time, the SBI had filed Section 7 application against Jet in NCLT Mumbai, which was admitted. And by the time the appeal of the Dutch liquidator came up for hearing in the NCLAT, the Jet insolvency was already admitted in India. And because Jet had the main office in India and maximum assets, so it was considered that the center of main interest or the main proceeding should continue in India. And the Dutch liquidator did not object. And there was a protocol. A protocol was entered into between the RPs of the Dutch and India. And then they resolved this issue, and those aircraft were sold, and then the amount was distributed to the Dutch liquidator. So this is one case where the cross-border insolvency was resolved minus the law, but through adopting a protocol. And the protocol is also, which is provided in the UNCITRAL guide. There is an UNCITRAL legislative guide, And in some other countries, the protocol, these same words are usually used. So, in the spirit of cooperation, the Dutch trustee aims to not take any decision under the Dutch proceedings that would adversely impact the interest of the company or the creditors. In the event it becomes necessary for the Dutch trustee, in compliance of the Dutch Bankruptcy Code or any other code or under any other applicable law, to take any decision that might adversely impact the interest of the company or the creditors, the Dutch trustee shall give advance intimation of such decision to the RP. So I will be moving on, but if there are any questions or observations, I am happy to take any questions or observations or doubts or clarification in case anyone wants. Okay, so let's move on. What is the applicability of model law on cross-border insolvency? So what is the then the main aspects? How do you understand? These are mostly related to the medium to large corporations, and it can be one corporation having assets and businesses in various countries. And again, main purpose is protection of business as a going concern, to seek a higher value for assets. However, there are certain causes for concern, and these are the treatment of secured and unsecured creditors in different countries. The rules may be different, the law may be different for the treatment who are secured and who are unsecured, as in India. Uh, During the resolution process, there is generally no classification made between secured and unsecured creditors. Rather, the distinction is between operational and financial creditors. Then, among the financial creditors, also now we have a distinction between the creditors having a charge on the project assets or unsecured financial creditors. And then there can be, in case of operational creditors, there can be employees, workmen, and so on. Only in the liquidation, this waterfall recognizes secured and unsecured creditors. So now there are, these approaches, and which we understand as a territorialist approach, where a country's creditors or a country law would uh, exercise its domestic insolvency law, and usually the domestic creditors are given a priority in realizing of the assets within its jurisdiction. And the foreign creditors may not be aware, and the foreign creditors may not be entertained as well. So there are disadvantages. And in case a country would want to choose such a system, certainly this will be a great disadvantage or great disincentive to the foreign investors. Then there is a then there is a universalist approach, and the universalist approach provides that the cross-border insolvency is administered pursuant to a single jurisdiction. The creditors are treated fairly and equitably. There is efficient distribution amongst the creditors. However, it is very difficult to get a pure universalist system. That is, you are equating the domestic creditors and stakeholders with the foreign creditors, and the domestic, there can be public policy concerns, there can be preferences or priorities in favor of few classes of people. Even, let's say, the workmen may be unsecured or operational creditors, but they are provided a statutory recognition. So there can be some concerns, and that is why we do not usually have a pure universalist system. Rather, we have a hybrid approach, which is a modified universalism or cooperative territorialism. So there are principles of universalism, that is, the foreign creditors' claims will be entertained and recognized on parity with the domestic creditors. However, if there are certain policy-based needs to recognize statutory claims of few people, for example, workmen, employees, or whatever, so those statutory public policy issues will also be there. So this will be modified universalism, or it can also be called as a cooperative territorialism, where there can be certain multilateral conventions as well. So in some Scandinavian countries, even within the EU, they may have a separate block. Okay, these are the four countries. We have a Scandinavian block, or there is a block like the US and Canada, and they have some different type of a approach that they will give preference to those countries in that close group. Then the main proceeding. What are the types of proceeding, right? So ultimately, it boils down to how the case is filed and which type of a case will be recognized. So the model law recognizes two types of proceedings. One is the main proceeding, which is based upon the center of main interest or common. And secondly is the non-main proceeding, which depends upon the place where the debtor has commercial establishment. So this is provided in the ancestral model law, and this is also provided in the draft part Z. Now some other concepts, key concepts. There is, the definition of foreign proceeding. So under IBC, the code, the terms insolvency, bankruptcy may not have been defined, but certainly there is a trigger point. When can an insolvency application be filed, and what can amount to an insolvency application? So it's basically that there is a default. If a debtor commits a default in paying to a creditor, then the affected party can file an insolvency application. So there are three types of insolvency applications: section 7, 9, and 10, which can be filed on the event of default. However, in most of the countries, this is not the scenario. The scenario in India is quite simplistic, but there are several grounds for filing insolvency applications. Several grounds for filing applications, and there are maybe multiple courts also. So, what may amount to an insolvency proceeding? So, in some countries like the US, there are bankruptcy courts. So, all insolvency actions must be filed in those insolvency courts. But in some other countries, even some civil courts may be able to entertain some actions which may be similar to insolvency. So then, the first question is, what will be a foreign proceeding which will be recognized as a cross-border insolvency proceeding? So this definition is provided in the Ancestral Model Law Guide, and this definition is also in the law, which means a collective judicial or administrative proceeding in a foreign country, including an interim proceeding pursuant to a law relating to insolvency, in which proceeding the assets and affairs of the CD are subject to control or supervision by a foreign court for the purpose of reorganization or liquidation. So, insolvency means a collective proceeding, and the same definition applies that it has to be a collective proceeding which may be of judicial or administrative in nature. Then the foreign representative means a person or body authorized in a foreign proceeding to administer the reorganization or the liquidation of the CD's assets or affairs, or to act as a representative of the foreign proceeding, and includes any person or a body appointed on an interim basis. The provisions shall apply only to the states who have adopted the ancestral model law on cross-border insolvency, or on any other state specified in Part B of the schedule, which the central government shall notify. So this is the draft Part C, the setup that we may have the law very soon. There are general provisions. So this cross-border law is also divided into six parts. So we have the general provisions and public policy. Then we have access of foreign representatives and the creditors to the adjudicating authority. Then recognition of foreign proceeding and relief. And then the fourth is cooperation with foreign courts and foreign representatives. Fifth is concurrent proceedings, and the sixth deal with miscellaneous provisions. So what is the availability of the cross-border insolvency framework in India? So kind of debtor, Part Z should apply only to corporate debtors, as the provisions of the IBC pertaining to individuals and partnership firms had not been notified, except in the case of individuals who are personal guarantors for corporate debtors. So whatever the part or the portions of IBC are in force, the cross-border insolvency will not extend beyond that. And even the cross-border insolvency may specify that the cross-border insolvency will be applicable only to these people. So even we do not know when the part 4 in its entirety will be notified, when the personal insolvency provisions will be notified in their entirety. It may also happen that the government may choose not to bring the individuals under cross-border insolvency. We do not know. It just depends, So, but all those uh, flexibility is there. So what is the place of incorporation? So the Part Z would apply to all entities incorporated with limited liability in India and in any foreign country. This would include domestic as well as foreign companies and the LLPs. Kind of business, the ILC recommended that certain businesses may be exempted from the applicability of the cross-border insolvency framework. And the business which may be so exempted are those whose resolution is governed by a special law, or whose insolvency gives rise to a need to protect vital interest of a large number of individuals. And the fourth clause of Part Z empowers the central government to notify the class or classes of corporate debtors or entities to whom the provisions of Part Z shall not apply. So this is the section 1 of the Part Z, and the first line itself is very clear. It says emphatically, the purpose of this part is to incorporate the ancestral model law on cross-border insolvency so as to provide effective mechanism for dealing with the cases of cross-border insolvency. And the objectives are also succinctly and objectively clarified and laid down. And the objectives are the cooperation between adjudicating authorities, resolution professionals, liquidators, corporate debtors, and other stakeholders, and the courts and other competent authorities of foreign countries involved in cases of cross-border insolvency. and to promote the greater legal certainty for trade and investment, then fair and efficient administration of cross-border insolvencies that protect the interest of all creditors and other interested persons, including the corporate debtor. So again, it emphasizes that the cross-border insolvency again is not, and so as the IBC is not only for the creditors but all interested persons, so all stakeholders. So IBC takes into account interest of all stakeholders, and it is not a debt recovery law like SARFAESI. Then D is protection and maximization of the value of the CD's assets, and E is the facilitation of the rescue of financially troubled businesses, thereby protecting investment and preserving employment. So this is the law that we have in India, the draft law, and it is modeled on the ancestral model law. Then section 2 is the public policy exception, which says, starts with a non-obstante clause, that notwithstanding anything contained in this part, the adjudicating authority may refuse to take any action authorized by this part if, in its opinion, the implementation of such action would be manifestly contrary to the public policy of India. So these are the some of the provisions. So authorization of resolution professional or liquidator to act in a foreign country, then access to foreign representatives. Then section 7 is on center of main interest. So these are the grounds on which the center of main interest will be determined. Then there are a few cases that I want to discuss. These are foreign cases, but I would like to cover them to better understand how these cross-border insolvency issues have cropped up and how they have been decided. So, although this may not be of a binding precedent for India, but it is a useful guidance for all the insolvency practitioners how the insolvency issues are are taken up, challenged, argued, and decided in some foreign jurisdictions. So, in case anyone has any questions, any doubts, you are most welcome. Okay, so let's start with this case, which is the Eurofood case. Now, what is the relevance of the Eurofood case? So it's interesting because when you read this, you can, I believe you would be readily be able to connect with some of these facts may sound to be similar. Now, this Eurofood was a subsidiary, and it was like a SPV, special purpose vehicle, and the holdco name was Parmalat. So Parmalat was an Italian company, the Holdco, which floated this Eurofood IFSC, and it was expected to be a SPV, special purpose vehicle, where Eurofood was registered in Ireland, and Ireland is a tax-friendly country, so that they could benefit from the low tax rates and take funding. Loans were taken in Ireland. There were lenders from Britain, from UK, from America. So banks, lenders gave money, lent money, loans to Eurofood in Ireland, and that money was used by the Parmalat Holdco to expand its business in South America. So Parmalat was basically into the dairy business, and they wanted to expand its business to South America. And for that, they constituted this SPV, Eurofood, got it registered in Ireland, took loans in Ireland. Lenders were from all across, from US, England, UK. So when this South American business was unsuccessful, Eurofood came under stress because it wasn't getting revenue and it had to service all of those loans. So Eurofood came into distress when this South American business, into which its funds had been utilized, came under stress. So now this Holdco Parmalat is registered in Italy, but the subsidiary Eurofood is in Ireland. So the uh, Holdco Parmalat filed one application in the court in Italy, which they called as a temporary administration order. And they probably had a sense that Eurofood is going into distress, and the bankers may file insolvency application very soon. So they filed an application in the Italian court, and that was not for insolvency, that was for a temporary administration. Then this so as you see here, in December 2003, Parmalat made an application for a temporary administration order for Eurofood in Italy. And but then the insolvency proceeding was filed in Ireland on 27 January 2004 by the bankers. So now what had happened, that this after this insolvency proceeding was filed and admitted in Ireland in January 2004, this Irish administrator went to Italy to get this uh, insolvency application or insolvency recognized and enforced in Italy. So there will be a moratorium. So he wanted that, okay, now this Eurofood is under insolvency and there is a moratorium, and I am the administrator. So kindly recognize and enforce this order of the Irish court. The Italian court did not recognize. The Italian court did not recognize. The Italian Holdco contested, and the Italian court did not listen to the Irish administrator, and basically just threw him out, that we are the Holdco, and there is a temporary administrative order, and we will not even listen to you. But by this time, apparently the Italians realized that this application in December 2003, which was labeled as a temporary administration order, may not be classified as an insolvency proceeding. So then in February 2004, they filed an regular insolvency application for Eurofood in Italy at Parma. So Parma was the place where the Parmalat Holdco was registered. Then this insolvency administrator, insolvency professional, went to Ireland to get this Italian insolvency recognized and enforced in Ireland. So the Irish court found that we cannot do that because they found that the Eurofood Center of Main Interest (COMI) was located was in Ireland actually. So but the Italian court argument was that Eurofood COMI was in Italy because its management and center of control came from its Parmalat parent holdco, which was located registered in Italy. So this was the basis for the Italian court admitting the insolvency application. But the Irish liquidator appealed, but the Italian appellate court did not consider the objections of the Irish liquidator. And so what is happening is that Italians have started their own insolvency application and they have not considered the objection of Irish. And in Ireland also an insolvency proceeding has commenced in January 2004. So, and then in the meantime, in March, Dublin High Court held that Eurofood COMI was located in Ireland because its registered office was located, and it appeared to the third party creditors that its COMI was located in England. So, mind you, this language, this comments appeared to the third party creditors that its COMI was located in England. So, the same phrase you find also in section 7 of the draft part Z and the rules and regulations. So this statement comes from this case, Eurofood, that it must appear to the third party creditor. So it's not sufficient that there is the registered office, but it should also appear to the third party creditors that they want the COMI to be in Ireland, which they have reflected in their loan agreements. In the loan agreement, they have entered into the dispute resolution clauses, the loan clauses for the choice of law clause or the governing law clause, and so on. So this statement and explanation and commentaries. If you have to make a commentary, this commentary comes from this Eurofood case, and whenever cross-border insolvency cases are argued, Eurofood certainly will be argued in India. So the Irish court held that Irish main proceeding had opened on 27 January 2004 when it had appointed the temporary liquidator. The Italian administrator appealed this decision to the Irish Supreme Court, which referred the matter to the ECJ, the European Court of Justice. So in the EU, so usually in the when there are cases in two countries, there is no international commercial court which can decide upon the commercial matters of the countries. So the ICJ, the International Court of Justice, it deals matters between countries. Subject matters are countries, not individuals. So this is not private law. This is private law. But in the European Union, because it's like a community, so they have a European Court of Justice, which is considered as a court of appeal from the countries of the EU, which is slightly similar to what we can consider at the time when the House of Lords had a jurisdiction of Privy Council when it was hearing the appeals from its colonies. So although there was no conflict, but basically it could be decided in the, so when there is in European Union, this matter, if it is decided by the European Court of Justice, it will be binding upon the courts of Ireland and Italy. So one principle that we have seen is that appeared to the third party creditors. Second aspect, also in the definition of COMI, was the date of commencement of the insolvency proceeding. So the date of commencement of the insolvency proceeding also arises from here, that as per the law, the insolvency application which was filed in Ireland was the insolvency application, But the application which was filed in Italy in December 2003 was not insolvency application, and that is why they had to file insolvency application in February. So I hope you are with me on this. So we have to understand these technical details. So even in the draft part Z, it says that what is the date of filing of insolvency proceeding. So as we can see here, the application which was filed in Ireland on 27th January was insolvency application, but the application which was filed in December 2003 in Italy was not insolvency application. And that is why uh, it also matters at what date the insolvency application had been filed. So when the ECJ had to give a decision, the ECJ law is that whenever prior in time an insolvency application is filed, then that usually that country will conduct the insolvency proceedings. So if there are grounds, and as we have seen here that in case of Ireland, the registered office of Eurofood was there, but in case of Italy, the parent or the nerve center was there. So both of these countries could have commenced the insolvency proceedings, and the EU law says that in whichever country prior in time the insolvency proceedings will commence, that country will be authorized to continue with the insolvency proceeding. The other country should stop its insolvency case. So in this case, it was decided by the European Court of Justice that prior in time, the Irish insolvency proceeding had started because the application which was filed in Italy in December 2003 could not be classified as a insolvency proceeding, and hence when we consider the definition of foreign proceeding, this is very relevant. What is whether this proceeding which was commenced may be classified as a foreign proceeding, and it will be classified as a foreign proceeding only if it were an insolvency proceeding. So the next issue is the COMI, Center of Main Interest, and the place of registered office. So usually the model law says that the registered office is presumed to be the place of COMI, Center of Main Interest, but it is not an irrefutable presumption. So this presumption can be rebutted. So there is a presumption in favor of registered office to be the COMI, but this is not irrebuttable presumption. So now what are the grounds under which this presumption can be rebutted? So the grounds on which this presumption can be rebutted are basically that the registered office is not the place of registered office. There are no substantial assets like a letterbox company, like we have these Cayman Islands, Bahamas, tax havens. Just the company is registered, but they have no substantial assets or office or workers. And there are several US cases where the companies are registered in the Cayman Islands or Bahamas, and the assets and the office are located in US. So the US have disregarded that the COMI cannot be considered to be Bahamas or Cayman Islands because it is only a letterbox company. It's only a office, and safely we can rebut the presumption of registered office being considered to be the COMI. So these were the questions which were addressed to the European Court of Justice, and the European Court of Justice gave its opinion on both the matters. That first of all, which was the insolvency proceeding, and whether the rule of priority will be applicable. So on the rule of priority, the ECJ said that first, that is prior in time, insolvency proceedings were commenced in Ireland because the Italian proceeding could not be classified as insolvency proceeding. And secondly, as far as the COMI, the place of COMI being considered as the registered office, whether it can be rebutted, this could be rebutted only on very strong factors. However, in these circumstances, there are no grounds to rebut the presumption that COMI will be at the place of registered office. So the court of the ECJ gave a decision that Ireland is the place of COMI and the proceedings should continue in Ireland only, and Italy should not continue with the parallel insolvency proceedings. So these are both the factors analysis which you find in the commentary, in the comments, and the provisions written under the Part Z and the regulations. What are the factors under which the COMI will be identified? So presumption that COMI is located in country of registered office will not easily be rebutted, but it will be rebutted like we have seen in case of Calcutta. There are letterbox companies. There is one street and thousands of offices are there in letterboxes, and there is no substantial business. So these are all letterbox companies. So in this case, the that registered office will not be considered to be the place where the insolvency proceedings should start. The insolvency proceedings should commence in those circumstances where there are substantial assets or control of the company. Now we move on to the next case. So before moving on to the next one, if there are any questions or doubts, one might want any clarification. So moving on to this next case, I will just explain this for 5 minutes and then we can have a short break. Now this is, the case upon which this 3 month time has been provided, 3 months look back period when the registered office is shifted. So in this case, there was this SR Interdil, which was an Italian company, and it shifted its office on 18 July 2001 to UK. So in July 2001, it shifted its registered office to UK from Italy. And the creditor in Italy filed an application, insolvency application in October 2003. So that was more than 2 years. So the difference, the time gap is more than 2 years. So after 2 years, the case is filed, insolvency case is filed, and certainly the company which has moved its office from UK, moved its office from Italy to UK, Interdil argued that I am not no longer registered in Italy, so insolvency application cannot be admitted against me. So and then the opposite party, which is Intesa, they argued that this Interdil was apprehending insolvency, and apprehending insolvency, they shifted their office. So the court held that even if they were apprehending insolvency, there must be some reasonable time, and they considered several cases, several instances, and they arrived at a reasonable time, that is 3 months. So in this case, it was held that 3 months will be considered to be a reasonable time as a look back period in case a company has shifted its office and the applicant, which is filing the insolvency application, wants to argue that the corporate debtor has shifted its office apprehending insolvency. So in that circumstances, 3 months look back period can be provided, but not more. So the rule for 3 months comes from this case. So Interdil, together with Eurofood, has provided some clarity as to the interpretation of COMI, which should be useful in future cases. And as is clear from the previous discussion, COMI is presumed to be the country in which the registered office is located. However, if a registered office has been moved within 3 months prior to the request to open insolvency or restructuring proceedings, that presumption can be rebutted. So, any questions, any doubts in case you might have? Can we take a short break of around 10 minutes, please? I'll just have a cup of tea. And we can rejoin after 10 minutes, 10 minutes past 11. Okay, so welcome after the break. So I was just, wondering if in case anyone has any questions or any observations, you might have come across any real life cases, you're most welcome. Now there are, I will share some more instances how these group insolvency, cross-border group insolvency were resolved. So there is this case, Daisy Tech, a 2003 case. So here the 2003 Daisy Tech, the holdco, committed a default and which caused problems for subsidiaries in Europe. And consequently, insolvency proceedings were filed in US, England, Germany, France. So in 4 countries, insolvency proceedings commenced. But in light of the case and considering the facts and circumstances, the English court was satisfied that the commie of each company in the group was situated in England, specifically in Bradford. The English High Court argued that the head office in Bradford was the coordinator and the performer of the European group, which included, for example, the negotiation of the supply contracts. So, what was the factor here? So, in this case, what was the factor which the British court considered they could use to consolidate the proceedings of the various subsidiaries and the holdco located across 4 jurisdictions into one place? And they considered that at Bradford there was a head office, and head office, by virtue of the control it was exercising over the entire group, that the main transactions were being concluded at that place. So this was, even though it may not be a very good or authoritative reasoning today, but at that time this was the reason upon which the court considered to consolidate this Daisy Tech company, the holdco and the subsidiaries. So the court provided detailed analysis of the evidences and factors which affected its final decision to adopt the head office function approach. The court placed particular emphasis on the claim that the center of debtors' main interest was ascertainable by the third parties. From the point of view of the English court, the third parties are the creditors. So, in the case of a trading company, these creditors are most likely to be its trade suppliers and its financiers. The court found that most funding was provided through English financial institutions. Furthermore, the court found that most of the factual evidence indicated that a head office in Bradford was managing and controlling all of the companies in the group. Following the important decision in the Daisy case, the same principle was applied in the case of MG Rover, where the English court rebutted the presumption in Article 3, Clause 1 that COMI is where the registered office of the company is located, applying instead the head office function approach. So again, there are issues. If you apply the registered office, then you cannot consolidate. So every holdco, every subsidiary will have their registered office. But for matters of convenience, and at that time there was no law, but they thought that we should be able to consider circumstances where the head office as registered, sorry, the registered office as the COMI could be rebutted. So in general, two different approaches have been applied: the registered office approach and the head office function approach. The registered office approach is more ascertainable by the third parties, especially creditors, and this has been supported by the CJU in the Eurofood and the Interdil cases. But in case the registered office has some office, or it has some activities, some assets are located, and also the third party creditors, it's not just that there is a registered office, but there can be a holdco and there can be a control at the place of holdco. However, the decision is to be made it whether the registered office may be considered to be the COMI, or whether that presumption can be rebutted. So if it is coupled along with the expectations of third parties, that is the creditors had satisfied itself. When the creditors, the bankers will give loan, they will do the due diligence, the assets, the location office, and in the loan contracts, they will also write those the choice of law, applicable governing law clause, the choice of courts clause, the dispute resolution clauses. So that indicates what is the intention of the creditors. So if all of that points that the registered office has been considered to be the place of COMI by the creditors, then the court usually will not intervene and will not disregard, will not consider to rebut that presumption and the choice expressed by the third parties. So this is a case which is not of cross-border insolvency, but which involved certain aspects of insolvency and the recognition of foreign insolvency order. So, we have, as I told you, we have covered the cross-border insolvency, and I shared a case on the cross-border group insolvency also. And this is a case which is like a cross-border commercial transaction, and which is usually a cross-border recovery suit, but involving certain elements of insolvency, judgment, and order as well. So, whether an insolvency, cross-border insolvency judgment order can be recognized and enforced in India, or whether a foreign, so not cross-border, basically a foreign. So, if a foreign order, insolvency order, or judgment can be recognized and enforced in India. So, this was a case of Sumikin Busan and Kingshing Enterprises. So Sumikin Busan was the judgment creditor, and judgment creditor Sumikin Busan had to recover some money from the debtor Kingshing Enterprises. Manohar was the proprietor and the guarantor, proprietor of Kingshing Enterprises, Hong Kong, and the guarantor to the Kingshing Enterprises. So this was a contract, some transaction in Hong Kong. Sumikin Busan and Kingshing Enterprises both were Hong Kong-based companies. But this Manohar Lal was a resident of Singapore, and So when this judgment creditor Sumikin Busan won the case in Hong Kong against Tengxing Enterprises, they will go to all the places wherever the debtors' assets are located. So they went to Singapore because Singapore, the assets were located of Tengxing Enterprises and the guarantor and proprietor Manhar Lal. So they went to Singapore to get the Hong Kong enforcement order uh, enforced. So execution order enforced. Then this Manhar Lal was, original resident of India, and he had owned some property in India in Bombay. So this Sumikin Busan of Hong Kong, because the judgment was given by the Hong Kong court, to commence execution proceeding against Kingshing Enterprises and the guarantor Manhar Lal. So they wanted to get this Hong Kong order recognized and enforced in India, in Bombay, against the property of Manhar Lal. So there are provisions in the CPC, Section 1314 CPC, which provides for the provisions for recognition and enforcement of foreign judgments and orders. And also there is Section 44A, which provides for the recognition and enforcement of foreign direct decrees, direct for the recognition, for the enforcement of direct enforcement of foreign decrees, but must be from a reciprocating territory and of a superior court. So there are two requirements for a foreign order to be enforceable under Section 44A of the CPC, and that is that the foreign court or the foreign country must be notified as a reciprocating territory under the schedule to the CPC, Civil Procedure Code. And secondly, that this order must have been given by a superior court. So initially, this Hong Kong company Sumikin Busan filed under Section 44A, and the Bombay court found that Hong Kong is not reciprocating territory, and hence this application under 44A for direct execution cannot be entertained. After that, this Sumikin Busan filed the regular application under Section 1314 of the CPC 13, and so the court found that whatever the objections are not there, and it can be recognized and enforced. So under the relevant provisions of it was valid under Section 13 and 14 of the CPC, and it can be recognized and enforced. It can be recognized. Now the question is whether it can be enforced. So it was enforced also in the sense that the property was attached. So property of Manhar Lal in this place, Bombay, was attached, and the realization, that is auction, was pending. During this time, Manhar Lal filed individual bankruptcy application in Singapore, and Singapore court admitted that bankruptcy application. So when a court admits the insolvency and bankruptcy application, there is a moratorium, there is a stay. So Manhar Lal brought that stay, bankruptcy stay of Singapore, to India and said that now I have a bankruptcy stay order, and now you should stay these execution proceedings which are going on against my property. So this is interesting because this is the law, that if there is a bankruptcy order, then it can be there is a moratorium on the assets, and it can be sought to be recognized wherever, globally, wherever the debtors' assets are located. So in Bombay, initially, the single judge bench considered that, okay, it's a Singapore court bankruptcy order, and we will recognize it, and we will grant a stay on the execution, that is the realization proceedings of the property. But later on in appeal, the division bench of the Bombay High Court uh, did not agree, and instead the decision was given on the ground that uh, whether the date of the admitting of insolvency application in Singapore is prior to or subsequent to the execution proceeding in India. So they found that the execution proceeding in India had already started, and after that, the Singapore bankruptcy court order was given. So hence now there is no possibility to stay those proceedings because they're already undergoing. So, accordingly, it could be inferred that had the execution proceeding not started, they might have considered the bankruptcy order. However, they have not given any decision whether they would have recognized or not. So, this is not a precedent, but it is an interesting decision how the courts can consider these foreign insolvency and bankruptcy orders. So this is an interesting case, and some of you might have come across such cases. And this is basically cross-border litigation, and these legal nuances and multiple laws are being addressed. Multiple laws are being applied and argued, and through multiple jurisdictions. This is all litigation and litigation strategy. So this is an interesting, which I thought may be of interest to some of you. Any questions? Let's move on to the next one. Okay, so now this is a case which is again on cooperation and coordination between courts. So we have covered some cases: cross-border insolvency, group insolvency, then recognition and enforcement of foreign insolvency judgment and orders. And now this is a case of cooperation and coordination. So this was the case of Maxwell Communication Corporation, and which was filed in the US and UK courts. So some cases uh, there can be only one proceeding which is based upon the COMI or the main proceeding, but in some cases parallel proceedings on concurrent proceedings can continue. So this was a case where the courts decided to continue with parallel or concurrent proceedings. However, showing a remarkable degree of cooperation and reconciliation of the laws of both the forums. So Maxwell Corporation followed a scandalous path which forced the international corporation into bankruptcy. At the time the company declared voluntary insolvency, it was headquartered and managed in UK and also incurred most of its debts in the UK jurisdiction. However, 80% of Maxwell's assets were located in the US, primarily its two major subsidiaries. Upon bankruptcy, Maxwell filed a petition for reorganization under Chapter 11 of the US Bankruptcy Code and simultaneously petitioned the High Court of Justice in London for an administration order similar to petition for reorganization. Concurrent proceedings in different countries, especially in multi-party cases like bankruptcies, can lead to inconsistencies and conflicts. However, the two courts independently raised with the respective counsel the concept that a protocol between the two administrations would be helpful, not only to resolve an impasse, but also to facilitate better and more timely exchanges of information. These parallel proceedings in the UK and US courts resulted in a high level of international cooperation and a significant degree of harmonization of the laws of the two countries. So similarly, in case of some courts, they exercise a remarkable extent of cooperation and coordination. There have been several cases where the case, for example, in US and Canada, so like in case of US and UK, the courts decide to sit at the same time. So the same time the time gap may be 5 hours. So in one court, the court time may be around 10-11 a.m. and another court, the time may be around 4 p.m. So, but they tried so that they are sitting in the same time and there is VC facility, video conferencing, and each court can look into the proceeding in the other court. Similarly, in case of US and Canada, they share the same time. So at the same time, there have been instances where at the same time, the courts have conducted proceedings on the similar matters. So at the same time, matter is being discussed in both these courts, one in the US, one in Canada, and there is video conferencing, and the proceeding can be seen, and you are not just waiting that okay, one court will listen, pass an order, and then that order will be sent to the other court, and then you wait for the response from the foreign court. So this is another level how this cooperation and coordination is done, and this is usually done through a network which is called as a Judicial Insolvency Network, JIN. So there are these Judicial Insolvency Network guidelines, JIN guidelines, and the JIN held its inaugural conference in Singapore in October 2016, which concluded with the issuance of a set of guidelines titled Guidelines for Communication and Cooperation Between Courts in Cross-Border Insolvency Matters, also known as the JIN Guidelines. The first JIN members contributed to the drafting of the JIN Guidelines. The JIN Guidelines received the most important overall development award presented by the Global Restructuring Review at the 2017 GRR Award ceremony held in June 2017. The objectives and function of the JIN Guidelines. The JIN Guidelines address key aspects of and the modalities of communication and cooperation amongst courts, insolvency representatives, and other parties involved in the cross-border insolvency proceedings, including the conduct of joint hearings. The overarching aim of the JIN Guidelines is the preservation of enterprise value and the reduction of the legal cost. And 16 states, I mean, it may not be 16 countries, but different jurisdictions. In some countries, there are maybe multiple, states who have power to join and enter into these separate arrangements and MOUs. So 16 courts have adopted these GIN guidelines so far. So any questions still here? Any questions or clarification that you might want?
These gym guidelines are mandatory. Are they recommendatory?
No, this is actually courts. Basically the promoter is Singapore court. The Singapore insolvency. There is a Singapore insolvency court, and they have promoted this GIN, Judicial Insolvency Network. And the judges from India, Supreme Court, they have also participated in this GIN conferences. So previously, Justice Arjun Sikri used to go. Now, Justice Chandrachud CGI has been participating in these GIN forums. So this is on court to court. So courts, basically the insolvency courts, superior courts, appellate courts have framed these guidelines, and the courts will adopt these guidelines. This is for court to court cooperation. So at the level there are cross border insolvency law which will create a cooperation mechanism for the adjudicatory authority and the resolution professionals. Apart from that, there is a judicial insolvency network which is connecting the appellate superior courts, which will actually guide the subordinate courts in that particular country. So this is the other aspect.
Okay.
Now, something about the history. Now, how did we reach here? I'll just, you might already be aware, but just like a refresher. So, as it's as early as in 2000 and 2001, we had these two committees, the Iradi Committee report and the Anil Mitra Committee report. So the Iradi Committee recommended that the model law on cross-border insolvency be implemented in India, and at that time to be amended in Part 7 of the Companies Act of 1956, and to consider the inbound and outbound request for recognition of foreign proceedings, coordination of proceedings in two or more states, and participation of foreign creditors in insolvency proceedings. Then the RBI constituted the Dr. Anil Mitra Committee in 2000-2001. So at that time, the RBI committee proposed the comprehensive bankruptcy code for India. So if you can, some of you might have seen, it is still there on the RBI website. The 2001 bankruptcy code, which was drafted by Dr. Anil Mitra committee, and they had also suggested that the cross-border insolvency should be adopted. So that those were the times that the government had taken a decision to do away with SICA and BIFER and constitute the NCLT. So the NCLT was so the BIFER was to be and the SICA was to be repealed in 2001, and then simultaneously in 2002 the NCLT had to be established. However, there was a legal challenge which was could be resolved only in 2014. So around 14 years it took for the NCLT legal hurdle to be removed by the Supreme Court, and only then the company's jurisdiction was shifted from the Company Law Board to the NCLT, subsequent to the Companies Act of 2013. And then when the IBC was enacted in 2016, the jurisdiction was given to the NCLT. So the IBC is also in a way helping NCLT and mandated that, okay, IBC has to be conducted through the NCLT only. But the decision was taken as early in 2001. However, it took some time and again political will. So the political will also matters, whether they they could have taken that decision at that time in 2002 itself. So, in the Companies Act, winding up proceedings under Companies Act of 1956. So, for companies registered in India, Indian courts have jurisdiction to hear and adjudicate upon proceedings, irrespective of the fact that the main business of the company may be carried out elsewhere. In such proceedings, India as well as foreign creditors can prove their debts. Then, companies that are not registered in India, winding up proceedings may be initiated under Section 584 of the Companies Act of 1956 if it had a place of business in India and in the following circumstances: if the company is dissolved or has ceased to carry on business or is carrying on business only for the purpose of winding up its affairs, if the company is unable to pay its debts, if the court is of the opinion that it is just and equitable that the company should be wound up. Then Section 13 and 44A of the CPC provide for the treatment of foreign judgments in reciprocating countries as conclusive, barring certain exceptions such as fraud, judgment not based on merits, not competent jurisdiction, etc. So uh, 14, Section 13, under Section 13 also the foreign judgments can be sought to be recognized and enforced in India. Section 14 provides for certain grounds for fraud, judgment not based on merits, not competent jurisdiction, etc. And if those grounds are not present, then the foreign judgment can be recognized and enforced in India. So this was the case that I had mentioned, Raja of Vizianagaram versus official receiver, which was decided by the Honorable Supreme Court in 1962. Foreign creditors of a company which is incorporated in England and carried on business in India can prove their claims in the winding up proceedings of the company as an unregistered company in India. The courts of a country dealing with the winding up of a company can ordinarily deal with the assets within their jurisdiction and not with the assets of the company outside their jurisdiction. And Section 271(3) says that the company incorporated outside India may be wound up as an unregistered company when it ceases to carry on business in India. So the cross-border insolvency in India, the way ahead, IBC had these two provisions, Section 234 and 235, which empowered the central government to enter into agreements with foreign countries and a letter of request to country outside India in certain cases. But it's difficult, you are just dealing on case-to-case basis, and this may take some time. There can be n number of requests, and this is not feasible. So it has not been resorted to.
So
Then
with how many countries we have such arrangement? Some letter of request has been gone.
I don't think with any country.
Okay.
So that is why there was the Part Z was adopted, and the cross-border insolvency rules were drafted in 2020. And now we have the draft Part ZA, which is group insolvency. So after Part Z, Part ZA has also been issued draft group insolvency. So this is where we are today. Questions, I am happy to take questions, detailed questions. Otherwise, I have some more cases which I can take up.
So what is the current state of affairs that group insolvency
Regarding
regarding the cross-border insolvency?
current state of cross-border insolvency.
Yeah.
Current state of cross-border insolvency is that there is no legal regime, and as we have seen in the case of this cell So it depends upon the host country whether they want to recognize or not. Otherwise, the existing channels which are for the service of instruments that will continue. But it is difficult and cumbersome. So this process is there. So even without a cross-border framework, but depends upon the discretion of the foreign court whether they want to recognize and enforce or not. And there have been several situations, several countries have actually refused. And another case was of Videocon, where the Videocon had assets in Brazil, but the creditor was, there was our banks, SBI was also there, and despite that Videocon assets being in Brazil, SBI was the creditor, and there was a joint venture in Brazil and also in Indonesia. So our bankers were there, and hence they facilitated. So it depends upon the bankers, it depends upon the creditors. So usually the PSBs take a lead through the government, through the diplomatic channels to actually get these legal issues. So yeah, I mean RPs. So again, in the Videocon case, it was mentioned that the foreign assets will also be included in the resolution plan of a CD.
So there was no creditor there in Brazil. How the Brazil
SBI
creditor?
SBI was there, and there were some local creditors also,
So how they were dealt with?
as per the law of Brazil.
As per the law of Brazil. Okay.
There are some more cases. For example, this relief. What type of relief can be asked? In this case of Platinum Partners, this is the Southern District of New York, 2018, recognition of Cayman Islands liquidation. US court ordered accountants to disclose information under discovery rules, even though this relief was not available in the Cayman Islands. Then we have these PUFE transactions, avoidable transactions, the preferential transactions. So what will happen in case of these avoidable transactions, or the transactions which can be avoided, PUFE transactions? So Article 23 of the code model law says actions to avoid acts detrimental to creditors. Upon recognition of foreign proceeding, the foreign representative has standing to initiate and refer to the types of actions to avoid or otherwise render ineffective acts detrimental to the creditors that are available in the states to a person or body administering a reorganization or liquidation. When the foreign proceeding is a foreign non-main proceeding, the court must be satisfied that the action relates to assets that, under the law of the state, should be administered in the foreign non-main proceeding. Then the discharge of debts are governed by foreign law. There is this famous case of Gibbs, which is an old case, 1890 of the UK. And this says that unless a creditor submits to a foreign proceeding designed to bring about the cancellation of a debtor's obligations will discharge only those liabilities governed by the law of the country in which that proceeding took place. So it's an old law, and it's has been very heavily criticized. That it basically says that if there is a creditor in England, and there is a resolution plan maybe in Singapore or in India, and the British creditor did not participate, so that resolution plan will not binding upon that British creditor. and it will be binding only in that particular country in which that resolution plan was finalized. So there are certain contentious issues as well, and the contentious undermines these cross-border insolvencies by requiring local proceedings to be opened to compromise local debts. And but it is defended as it aids in contractual certainty. So it's an old case, and British common law is old, and it helps their law. And even though they say that it's not resorted in several cases, but they have not changed the law or overruled it. So that will be all from me, and questions are welcome, or any other observations. So I mean, I have shared the PPT with you, and I'm sure the institute will also share that PPT. So, I mean, in case you have any questions or any doubts, anything, you're most welcome. Any particular concept? Okay, thank you all. I will leave now, and thank you for the time, and I hope this session was informative for you. And my PPT is there. The email is also on the PPT. In case required, you're most welcome to reach out to me.